Good morning, everyone. My name's Tom Lees, Key Relationship Manager here at Lawyer Checker. Thank you very much for joining us on this rather chilly December morning for our webinar on funds transfer fraud. Think it couldn't happen to you. Thank you very much for joining us this morning. The objective from today is to talk about and take learnings from a number of high-profile case studies that have featured within the national press this year that I often use as a reference point when talking to law firms about real instances and fraud and cybercrime and the effect that they have had on those businesses. The webinar will be about 25 minutes long, and we'll talk through these 5 or 6 case studies. Should you have any questions, obviously you've got the questions box on GoToWebinar. You'll be able to type your questions in there, and then if we've got time, I'll try and cover a few off at the end. If we run a little bit over, then I'll make sure we will reply to you individually with those. Really thank you all for taking the time out to listen this morning. Had over 200 people register for this webinar, which I think in December just goes to show how important a subject and topic this is. We also have people listening in from as far away as Italy. So good morning for the person who has subscribed and signed up from Italy this morning. So many of you will know me in terms of a lot of our previous webinars. I am Key Relationship Manager here at Lawyer Checker, looking after our clients in the north of England. Lawyer Checker, leading provider of risk management solutions to law firms, hopefully acting as your one-stop shop for everything fraud and cyber related. We also own and publish Today's Conveyancer and Today's Legal Cyber Risk, so well versed in talking about this area. So I'm going to jump straight into the first case study. This is one of the newer ones that the eager-eyed amongst you will have read a couple of months ago in The Guardian. So, gentleman on your screen is a first-time buyer called Nikhil Dudeja. Nikhil and his wife were due to buy their first home. They'd saved a £45,000 deposit with a mixture of savings and help from Nikhil's parents. While they were away on holiday, Nikhil received an email from his solicitor asking for the deposit money to be paid. He went into his Lloyd's banking app and transferred the sum over in two payments. 5 months on, and their dream of home ownership was in a pretty sorry state of affairs. Fraudsters had hacked into the estate agent's email system and had seen enough about the transaction to create a fake email from his lawyer telling him where to send the 45,000. So rather than that money being sent to his solicitor's account, it instead went into a HSBC business account that had been fraudulently set up in Kilburn in North London. The Metropolitan Police investigated a number of suspicious account openings at HSBC's Kilburn branch, and in a letter sent to Nikhil, which was seen by The Guardian, according to the story, the police said they were investigating if the fraud was facilitated by an insider. The client, who was quite, as you would if you'd lost £45,000, really passionate on sort of tracing this fraud back, seems to lay a great deal of the blame at the bank. So he says that HSBC should have spotted that the receiving account was fraudulent, as it was opened online with company details that the police said didn't appear to exist. They're not the first people to receive or be a victim of this type of fraud. The client uses the word devastating when talking about the experience, and one of the key learnings from this is, although if you read the article in full, the blame is very much apportioned at the door of the banks, and quite rightly so, because there is certainly a great deal more that banks could do here. One of the things that's referenced in the article is the name check. So obviously at the moment, when you send funds, that the name check doesn't match up. We're led to believe that that might finally be implemented next year, but I was speaking to someone only a few weeks ago who knew someone who was working on this project, and it does seem like it's some way from being live and acting as a real layer of protection. And one of the really interesting learnings is this. So the email I received came from the exact address is used by our solicitor. The bank details were provided on the solicitor's company letterhead, along with the signature of the solicitor dealing with our case. I was expecting to make payment and just did so. It was the perfect scam. And although as I said there, the blame is apportioned at the banks, obviously the estate agent needs to take some brunt of that. And with the right protection in place, actually the solicitor could have been the hero in this story. In that if they had a layer of protection called DMARC in place, which would have stopped their exact email being impersonated, you get the impression from the story that Nikhil may well not have fallen for the type of attack where it was a different email address. We'll never know, but I certainly think there was an opportunity there for the law firm to be the hero and to be the one that rescues that transaction. The client is still going through, if you read the bottom of the article, the rumblings of compensation. HSBC and Lloyds, the two banks involved, have pretty much washed their hands of that one. So I think that's a really interesting story, and I'd encourage you to have a read of the full article, just because it has lots of different touch points, of which I all think are relevant to certain degrees. So definitely worth a read, that one. But for me, key takeaway from that one is two things. Number one is regards to the email. Second, and one that I think needs to start becoming very much cultural, is to ask the question, what did the law firm say to their client at the time of instruction when they initially first spoke to him about what their processes were with regards to the transfer of deposit funds. So if the law firm knew the client was going away on holiday, should it not have almost recognised that this could be a potential minor red flag that a criminal might look to exploit? Could they have laid out verbally to Nikhil at the start exactly how they wanted him to pay deposit funds and how they would never send those bank details in an email? As soon as those bank details are sent in an email, you're playing right into the fraudster's hands, in my opinion. So second story is a fairly well-known one. This is from earlier on this year. Similar but slightly different story to the first one. So this is where Nicola McConnell was selling a property in London for just shy of 2 million. On the day of the contracts were due to be exchanged, the law firm received an email pretending to be from Mrs. McConnell, saying she wanted 50% of the transactions to go into one account and 50% of transactions to go into the details that she had already provided. The article states that she actually provided those details via a handwritten note, which was passed through the letterbox of the law firm. So initial red flag would be that they received an email on the morning of exchange. That would be unusual, I would have thought, in a client like that who's clearly gone to great lengths to send details through the post. The firm in question then did not send the money straight away. They picked up the phone to the client. She was moving, she was busy, she didn't really understand the call, so they transferred the money. It was obviously only when Mrs. McConnell said, "Where are the rest of my proceeds?" that they looked at this case and they found the criminal had used an email with one digit difference to Mrs. McConnell's, and they were able to recover a large amount of the money, but not all. And the gentleman who appears on my slides here was actually arrested. That's quite unusual that arrests happen over this type of fraud. He was arrested, clearly the bottom of the food chain. So remember, this is organised crime, not teenagers in their bedrooms. And he was sentenced for 5 years. Sorry. Couple of takeaways from this is number one, to always use an independent verifier of clients' bank details. So we have a product called Consumer Bank Account Checker. If the law firm had used that, it would have stopped this fraud from happening, and the client would have ultimately been protected. And the last one is also, when you are on the phone confirming bank details with clients, which is and can be an important layer of protection, it can be very easy to drift into autopilot, which I think, judging by the article, that's what the call to Mrs. McConnell was. And I think being able to make that call realistic, potentially with some sort of security question in it, would have really helped. That would have really helped stress the meaning of that call. All key takeaway again is that all cybercrimes are expensive to law firms. So in the recent SRA Risk Outlook, one study found that breaches cost the average law firm £4,180, rising to just over £22,000 for the larger firms. So we've looked at, in the first two stories, a little bit about the emotional element of these, not just for the individual, but for the law firm. We've looked at some of the financial loss as a result of the money going missing, but there's also a real knock-on effect in terms of how much resource it costs to fix and resolve these problems once they've happened. This one appeared again this year, so this was referenced a couple of times. It was actually referenced in the first case study that we looked at in the Guardian story. Howard Mollett was in the final stages of buying a flat in South London when fraudsters struck with him. So his offer on the flat was accepted in 2016, and he appointed a law firm to act as his solicitors. On the 29th of September, he transferred 45,000 from his Barclays account to his solicitor's legitimate bank account at HSBC. However, a message from his bank popped up on his screen telling him that the funds could take up to 3 days to clear. He had to make the transfers online, and he was travelling abroad for work at the time, and realised that if that was the case for all the remaining transfers, he would miss the completion date. Mr. Mollett says that the solicitors emphasised how important it was to ensure all the funds reached them on time. So he emailed the firm that same day asking about the best way to get the rest of the money, which was just shy of 75,000, to cover the remaining deposit, so stamp duty and fees, to then sort of meet the deadline. It was at this point the fraudsters contacted him using the email address of the member of staff who he had been dealing with all through the process. Obviously, at that time, Mr. Mollett wasn't aware that the emails had been hijacked and impersonated. That email then stated that the firm's usual bank account could not receive chaps or backs payments, and advised him to pay the money into its Yorkshire bank account. So he obviously transferred that 42,000 into the Yorkshire bank account. Naturally, that money was sent to a fraudulent account, because the law firm had their emails intercepted. For me, the big takeaway on this, there are obvious takeaways that mirror the first case study. So DMARC with regards to having the email impersonated. I would be really wary about discussing bank details in an email with a client. Clearly what has happened here is the criminal has been monitoring the conversation and has picked up on the key words within this, and has honed in on those. This client was also traveling abroad with work. So I think you've got to find an appropriate way to engage with those clients who maybe are abroad or overseas or on holiday, without obviously having a negative effect on the customer experience. And again, I wonder if this goes back to the very start of the transaction as to how the law firm relayed how they were expecting Mr. Mollett to pay his deposit funds to them. So in CQS this year, you will note that in section 6.2, there is an area where it talks about being able to ensure that you deliver your messages to your clients about how they send money to you in a safe way. So I think this is really an education piece in terms of your first meeting with the client, your first call with the client. You're really stressing that you're never going to email them your bank details. You're never going to email them that there's a change in bank details. You might encourage them to call you before they send payment. You might encourage someone to send a test payment. There are lots of methods out there that aren't being used regularly enough that would stop this type of thing happening. And that's just part of the people part of the golden triangle. You've not even looked at any technology or process. It's just a real fundamental part of the people side of things. This is quite and a really interesting story, this one. So this is from outside the legal sector, but there's a real clear message. So this is really a focus on sort of whale fishing and CEO whaling fraud. So Patricia Riley worked as their credit controller for a media company in Scotland when she was scammed by email fraudsters on October the 9th, 2015. Reason why the story is a few years old is it's only just finished its High Court judgment, which we'll come on to in a second or two. The impersonation fraud or whale fishing attack started on October the 9th. The fraudsters claimed to be the managing director of the company, who had ordered 24,800 to be paid by Chaps, a payment that would clear on the same day the request is made to one of the company's clients. Before that initial payment was made, Patricia Riley consulted her line manager, who then issued the payment to be made. The managing director, a lady called Yvonne Bremner, and Riley's line manager were on holiday. 3 more attempts from the criminal were successful. So this is where they were purporting to be the firm's managing director, asking for payments to be made. During this time, Mrs. Riley made 3 separate payments totaling 193,000. The company claimed that although the emails were sent from somebody claiming to be the managing director, they were not sent from Yvonne Bremner's email account, something that Patricia Riley should have been aware of. The crux of this article is that the company tried to sue her for £107,000. However, recently a High Court judge in Scotland's highest civil court finally ruled in her favour, and she was allowed finally some peace from this. You can imagine the effect that no doubt this would have had on her. And people often forget about the internal threats of email modification fraud. So this is a typical attempt at CEO whaling fraud. So those of you that work in things like accounts, finance departments, HR departments, these are the type of things that will be directed in your direction, and I think it's really important that you're aware of them and that you have a process for managing those sort of internal requests. A lot of clients that I sit in front of tell me that they see quite regular examples of this, and this is another instance where if you get DMARC set up, which Lawyer Checker can help you with, you can stop people impersonating managing directors and managing partners. This is a really new case study, so only been in the press since the 17th of November, as you'll see if you look very closely at the screenshot. So this is ID fraud, really a growing problem, which many of you will be aware of. One of the things you can do to see just how growing a problem this is I would encourage you to Google the phrase buy fake bank statements, and it will take you to a website called banknovelties.net, where you can see how easy it is to buy a fake bank statement. It's not very expensive either. They normally range between about sort of £35 to £60. So this case here, a lady called Sarah Broadbent took out a passport uh, under her new identity of the name of Marion Patterson, the name of the legal owner of this property, that she had changed her name via deed poll to sell a £75,000 house without the real owner knowing. The scam was only really rumbled when the real owner, the genuine Marion Patterson, tried to sell the property and was told it had been sold 4 months earlier. Lady on your screen, real name Mrs. Broadbelt, has been jailed for 20 months, having previously admitted charges of fraud and possessing a false identity document. The prosecution described this as brazen and calculated, and was a fraud that struck at the heart of the conveyancing system. And I think that's a really powerful takeaway from this, is this type of ID fraud, unless you using the right technology, is going to be very difficult to spot. Passing sentence, the judge, Michael Chambers, said you played a prominent role in a sophisticated fraud to deprive the owner of the house of its ownership. So the court heard that the real Marion had the house in Welsh House Farm Road, Quinton, valued at up to 200,000, having rented out the home she had owned since 1993 after she had moved to Cornwall to get married. She was warned by Birmingham City Council that it was allegedly being used for benefit fraud by tenants, but still decided to put it on the market. I think benefit fraud was probably the least of her concerns by the end of this. So on the 22nd of January, an estate agent rang up and told her house had been stolen. She said it had been sold to a buyer in October 2015 for 75,000. The fraud was carried out after Broadbelt changed her name by deed to Marion Patterson and managed to obtain a passport in the owner's name. A few days later, she obtained a second passport to distance herself from the name change. The false document was then used by her to open 2 accounts, one with Halifax and one with Barclays. Obviously, the criminal also went to a firm of solicitors so the sale could be carried out. The firm noted that according to the documentation, she bought the property when she was 6 years old, but she managed to persuade the firm there was a trust in place. The proceeds of that sale were then sent to the accounts that had been opened and were withdrawn in large sums over the course of 5 to 6 days. The red flag there is clearly that the property was bought when she was 6, but somehow she managed to persuade them that there was a trust in place. Now, there is pieces of technology that can help stop this. So, for example, Lawyer Checker's third for ID and source of funds solution would have stopped this. The electronic ID check which it carried out would have noted the relevant differences within the Experian address match. It would have raised a number of red flags within that. And also, if you would have used that level of technology on a genuine fraudster, I think that genuine fraudster would just go somewhere else, because fraudsters are clever people. That they know that when firms are using high levels of due diligence around technology, that they can just go to someone who isn't to carry out that fraud. So again, key learnings from this were the red flag that she bought the property when she was 6 years old, and use the technology to help with some of these ID challenges. If someone comes into your office and gives you a passport or driving license, it is really difficult to ultimately know whether that's a genuine piece of identification. With Lawyer Checker's third thought, it uses something called on-FIDO technology that will tell you whether it's a genuine piece of ID. And then to finish off, a couple of other small case studies. We won't cover the phishing one because we kind of already talked about CEO whaling fraud. Vishing, this is when a criminal uses the phone to try and dupe the person at the other end to transferring some money, giving away some confidential information. This one here was where the fraudster proposed to be a bank relationship manager, managed to convince a partner to transfer money to another account. It was only when his fellow partner came back later that day and said, "Are you really sure about that?" that they found out this had happened. The criminal had played on the ego a little bit of the managing partner by actually telling him that he would normally speak to the cashier that he deals with, but he was aware that she wouldn't be able to authorize this type of transaction. And at that, the last time I heard about this case, they had not recovered the money that had ultimately gone missing, and that the bank had refused to do so, as they felt this was a genuine case of human error. So to wrap up this morning, if any of the areas of risk that we've talked about this morning resonate with you, you will be able to book a call either this month or moving into January with your key relationship manager at Lawyer Checker in order to talk about how we can help you with some of these challenges that you might have been able to identify. We do a number of things to help our clients, and clients hopefully see us as very much a one-stop shop for fraud and cyber. So we can help you with regards to the money transfers with our 2 money transfer products. We can help you with some of the challenges around email modification fraud. We can help you from a cultural perspective with regards to training and cyber security. I know I mentioned CQS a little bit earlier, but all of these processes that we're kind of looking at here form a really key part of the new CQS. I was actually sat next to you may well be aware that they're now doing real life assessments on CQS, and I was sat next to the country's lead assessor at a dinner a couple of weeks ago. He was stressing the importance of these processes. So my call to action for you is, if you want to book your consultation with your key relationship manager, there are 2 ways that you can do this. You can either email me on the details that are on the screen, or you can give me a call. I will be back at my desk in 5 minutes, so you can give me a call then. Or in our follow-up email, we will send a calendar link that you can book a specific time in for January or later this month, maybe when things have started to die down a little bit, if you've got some time in the diary. But we'd be delighted to help you with some of the areas. Hopefully the talk through the case studies has been interesting. And you find that useful. Thank you very much for your time this morning, everybody. Enjoy the rest of your day and look forward to hearing from you all soon. Bye bye.